Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it
Please.
and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the president's speech announcing it, registered the domain name. And so
Is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 USC Section 3, it's my responsibility to advise the President through the Secretary of Commerce on matters of national security and all matters of intellectual property.
So the Board of Peace is a public entity? It's a governmental organization even though Congress has not created it? Is that right?
Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the president call you about the cyber squatting incident?
No, the president did not call me. It came up through several organizations about the cyber squatting, and the action needed to be taken to
When you
address the
talked
harm.
about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, peace committee, world peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, a reference was made to Shakedown. This was registered, this particular boardofpeace.org, and without that, you don't have the
You
ability.
registered that?
No.
Oh, who registered?
A cyber squatter did. I mean, 8 minutes into the
But
president's
you don't
speech.
have to talk about a cyber squatter. There are dozens of other groups that have peace in their name, right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 USC 3 and 35 USC 2 under the Lanham Act, and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 USC Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
the website says $350, is that right?
Generally, yes.
It's not expensive, okay. And one of the able lawyers on my staff just passed me this, you filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay, but
I do believe it's in
your
my authority.
signature,
Yeah.
okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
Yes.
why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and
by
then
someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the trademark office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 U.S.
All right, so let's talk about what you just watched, because that was not a normal oversight hearing. That was the head of a federal agency sitting in front of Congress trying to explain why he personally, within 8 minutes of a presidential speech, filed trademark applications for a project that has no legal existence, no incorporation, no congressional charter, no treaty. And his defense was, I was acting as a custodian to prevent fraud. When a president announces a new initiative, cyber squatters race to register domain names within minutes. Government officials argue this forces them to act fast. But legal experts warn that when an official files a custodial trademark on behalf of an unformed entity, it raises serious questions about jurisdiction, executive overreach, and the misuse of taxpayer resources. The USPTO has only ever held 7 trademarks in its entire history, all for its own operations. Filing on behalf of an external presidential initiative is completely unprecedented. Now here's where it gets legally indefensible. Under the Lanham Act, which has been federal trademark law since 1946, you have to be the rightful owner of a mark or a legally authorized representative to file. You also have to show a bona fide intent to use the mark in commerce. The Board of Peace is not a registered entity. Congress didn't create it. No treaty establishes it. So who is the owner? Squires says the USPTO is holding it temporarily, but the Lanham Act doesn't have a maybe later provision. You either own it or you don't. Under the Lanham Act of 1946, an applicant must be the rightful owner of the mark or a legally authorized representative and must demonstrate a clear intent to use the mark in commerce. If an entity has not been formally established by Congress or international treaty, a government employee lacks the statutory authority to act as its legal representative. The Board of Peace has no registered legal structure anywhere in the United States. By the letter of the law, these applications may be void from the start. And then there's the fee waiver. This is the part that should make your stomach turn. The standard trademark filing fee is $350. Squires filed the application and then a petition to waive that fee was submitted and granted the very next day by another official in the same office. Overnight, the same agency that has what Squires himself called a crushing backlog somehow fast-tracked a fee waiver for its own boss's application. Every small business in America waits in that line. Every entrepreneur pays that fee. But when the president needs branding work, the rules just disappear. The USPTO requires standard filing fees and follows a strict chronological processing queue. In the case of the Board of Peace applications, the fee waiver was requested and approved overnight by officials within the same office that filed the application. When the agency filing the trademark is also the agency granting itself a fee waiver, it creates a glaring ethical conflict that bypasses standard protocols and gives the executive branch preferential treatment over hundreds of thousands of ordinary American businesses. Now zoom out, because this is bigger than one filing. The separation of powers exists for a reason. Congress creates entities and allocates funding. The executive branch administers. But what happened here is the executive branch secured intellectual property for a project Congress has never debated, never authorized, never funded. That's not administration. That's unilateral creation. And it transforms the Trademark Office from a neutral arbiter of commerce into a political tool used to legitimize whatever the president announces at a podium. A unique constitutional friction occurs when the executive branch secures intellectual property for programs that Congress has not authorized or funded. Legal scholars point out that allowing the president or their designees to unilaterally claim trademarks for unformed initiatives circumvents legislative oversight entirely. It transforms the Trademark Office from an independent arbiter into a political instrument used to legitimize impromptu policy announcements before they undergo any democratic scrutiny. Announcements before stop to Messiah, in Fortin Althemize Dick, not Sal. And here's what should really bother you. Federal employees are bound by strict ethical guidelines. They serve the public, not any individual politician. But when a government official takes rapid legal action 8 minutes after something the president said in a speech, not based on legislation, not based on a formal directive, but based on a speech, who is the actual client, the American taxpayer or the president who floated the idea? Because Squires didn't file these trademarks because Congress told him to. He filed them because Trump said the words Board of Peace, and he jumped. That's not fraud prevention. That's branding work through the Patent Office. Federal employees must act in the interest of the public, not as private legal counsel for political figures. When a government official files legal petitions to protect the branding of a proposed initiative within minutes of a presidential speech, it raises the question of who the actual client is. The USPTO director acted not on a congressional mandate or formal agency directive, but on a political announcement. Ethics experts argue this crosses the line from public service into political brand management funded by taxpayer resources. And Raskin asked the question that exposed the whole thing. He looked at Squires and said, "Do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump? Is that a service you offer to all American citizens? If I'm thinking about creating a group someday, will you go ahead and file the application for me?" Squires dismissed the question because the answer is obvious. No. He doesn't do this for anyone else. 7 trademarks in the agency's entire history, all for itself. This was the first time ever. Now the cyber squatting defense. Let's take it seriously for 1 second. Someone grabbed the domain name minutes after the announcement. That's a real thing that happens, but there are established legal channels for dealing with it. ICANN dispute resolution, the Anti-Cyber Squatting Consumer Protection Act. You don't need the director of the Trademark Office to personally file applications and skip the entire standard process. The urgency argument sounds reasonable until you realize that acting fast doesn't mean acting without legal authority. Congressional oversight committees have the authority to subpoena officials, demand internal documents, and hold public hearings to ensure executive branch agencies operate within the law. During the March 25th hearing, lawmakers pressed Director Squires on the legal basis for acting as a custodian, the internal fee waiver process, and who authorized the filing. The purpose of such hearings is to deter federal employees from treating taxpayer-funded departments as personal instruments for the sitting president. And here's what gets buried under the procedural back and forth. This Board of Peace has collected billions from foreign governments: Saudi Arabia, Kazakhstan, Azerbaijan, UAE, Qatar, Bahrain, Kuwait. Trump declared himself chairman for life. Nobody knows what country the bank accounts are in. Congress has never seen an audit. And by filing a trademark, the USPTO is essentially confirming this is a commercial enterprise, not a government body, which means the emoluments clause is directly in play. Foreign money flowing to an entity controlled by the sitting president, and the Trademark Office helped make it official. Cyber squatting is a real problem that occurs when opportunistic individuals rush to register domain names after government announcements. However, established legal channels already exist to combat this, including ICANN dispute resolution and the Anti-Cyber-Squatting Consumer Protection Act of 1999. These processes do not require the head of the Trademark Office to personally file applications or bypass the standard queue. The urgency defense does not address the underlying question of legal authority, which no official has been able to cite. And there's one more layer. When the federal government owns a trademark on the phrase Board of Peace for peace facilitation services, anyone who wants to criticize it, satirize it, or organize against it now has to wonder if they'll get hit with a trademark claim from the United States government. Raskin listed over a dozen existing peace organizations with their own marks: Global Peace Foundation, Peace Action, Greenpeace. The mere existence of a government-held trademark creates a chilling effect on free expression. That's not intellectual property protection. That's a speech suppression tool with a federal seal on it. So here's the line. The director of the USPTO personally filed trademark applications 8 minutes after a presidential speech for an entity with no legal existence. The agency is both the applicant and the reviewer. The fee was waived overnight by a colleague down the hall. The entity has collected billions from foreign governments with zero congressional oversight, and the president declared himself chairman for life. That's not fraud prevention. That's a federal agency doing branding work for the president on your dime. And if that doesn't bother you, imagine the next president doing it, because that's the precedent being set right now on camera. That's it. Like the video, subscribe, share it with someone who needs the full picture. I'll see you in the next one.